answer those questions. There is no one-size-fits-all approach. While national implementation should respect, and I emphasize, should respect international obligation and customary law, it must also give due regard to a country's idiosyncrasies and domestic priorities. I thank you.
On the ICC and what we are doing in Liberia, I want to thank you very much, Honorable Attorney General. We will then continue with our opening remarks and statement. We will now go to this next stage where we will take a presentation by Ms. Fatou Bensouda of Gambia, the Deputy Prosecutor of the International Criminal Court. Madam, you are welcome.
Thank you, Honorable Chairperson. Your Excellency, the Attorney General and Justice Minister of Liberia, Your Excellency, the Ambassador and Head of Delegation of EU to Liberia, Attilo, Pacifici, Honorable MP, MJ, Honorable. I'm thankful for being here, and I'm grateful to the PGA for this kind invitation. I'm going to say this with the greatest respect to those who know about the ICC, but which I feel is important to say, because there is still some misinformation out there about what the ICC is. The ICC, International Criminal Court, is not to be confused with any of the ad hoc or special tribunals, such as the International Tribunal for the former Yugoslavia, or the Special Court of Sierra Leone, or the Special Tribunal for Lebanon, or the International Tribunal for Rwanda. Many a times in such fora have I been asked, oh, you are prosecuting Charles Taylor. And I say, no, the ICC is not prosecuting Charles Taylor. Charles Taylor is being prosecuted by the Special Court of Sierra Leone. And they will go on to ask, but you also prosecuted Milosevic. And I said, no, the ICC did not prosecute Milosevic. Milosevic was prosecuted by the International Criminal Tribunal for the former Yugoslavia. But you have now started the Hariri trials. And I say no, the Hariri trials are not the ICC. It is the Special Tribunal for Lebanon. And so on and so forth it goes. And this, of course, always shows me that the ICC is being confused by other ad hoc tribunals and other special tribunals. I hope at the end of this intervention, and also with the assistance of previous presenters, I hope that this should be clear to all of us present, that ICC was created in 1998 under the guidance of the then Secretary General Kofi Annan. He led the conference in Rome that resulted in the conclusion of the founding treaty of the court, which is the Rome Statute. When the world had failed to prevent massive crimes, the decision of Africa, of Europe, and South America to build an international criminal court was not just a matter of principle, it was a matter of realism. It is a strategic priority to avoid a repetition of the experiences, such as the Rwanda genocide, which resulted in the death of 1 million people or more, and floods of refugees to Tanzania and to the Democratic Republic of Congo. After the creation of the ICC in 1998, in February of 1999, Senegal, an African state party, became the first state party to ratify the Rome Statute. The course of international justice has never decreased, and currently, as has been said by previous speakers, 31 African countries are states parties to the Rome Statute, and thereby forming the largest regional group to ratify the Rome Statute. African judges form 28% of the court's bench, and this clearly demonstrates the high level of responsibility expressed by the African continent. States in other regions, Canada and Mexico, Japan and South Korea, Jordan and Afghanistan, Australia and New Zealand are also states parties to the Rome Statute. They all have chosen the law as a tool to protect their citizens and their land. And this is the main concept: states parties under the protection of the court. The Rome Statute offers a solution to massive border-crossing crimes as a new instrument of peace, creating global governance without a global government, but with international law and courts. Accountability and the rule of law provide the framework to protect individuals and nations from massive atrocities and to manage conflicts. Under the Rome Statute, substantive law has been codified into one detailed text. States have reaffirmed their duty to prosecute the worst criminals. An independent, impartial, and permanent international criminal court has been established. The drafters of the Rome Statute also clearly recognized the intrinsic link between justice and peace. And as stated in the preamble to the Rome Statute, by putting an end to impunity for the perpetrators of the most serious crimes, the court can and will contribute to the prevention of such crimes, thus having a deterrent effect. The Rome Statute is based on two principles: complementarity and cooperation. All the states parties to the Rome Statute committed to investigate, prosecute, and prevent massive crimes when perpetrated within their borders or their own jurisdiction. They accepted that, should they fail to investigate and prosecute, the ICC could independently decide to step in. Proceedings before the ICC, as a court of last resort, should, however, remain an exception to the norm. The primary responsibility for the prosecution of the gravest crimes lies within the national jurisdictions. And in order to give effect to this responsibility and commitment, it is important that the core values and provisions of the Rome Statute find their way through to domestic law. Only then can states are able to conduct proper investigations and prosecutions and prevent the massive crimes that have plagued their countries and their continents. Under the Rome Statute, and wherever the court decides to act, the court can therefore rely on the cooperation of all the police of all states parties to implement its decisions. This is not just an abstraction. Cooperation with the court is a fact. The Democratic Republic of Congo has surrendered 3 of their nationals to the court. The Belgian police implemented in one day an arrest warrant against Jean-Pierre Bemba, a former vice president of the Democratic Republic of Congo. And in October of last year, France, cooperating with Rwanda, a non-state party, and the court, did the same with regards to Cllr Mbarushimana, a leader of the Force Democratique pour la Libération de Rwanda. It's available under national law for all the forms of cooperation specified under Part 9 of the Rome Statute. relating to international cooperation as well as judicial assistance. Besides, to execute arrest warrants, cooperation is also necessary for assistance, for instance, to assist the court with the protection of victims and witnesses, the taking or seizure of property and assets. The strength of the Rome Statute, the strength of this system lies thus in the possibility for shared responsibility and complementarity action between the court and national institutions. Your Excellencies, ladies and gentlemen, these are the concepts defined by the Rome Statute. Let me in short explain how the Office of the Prosecutor is trying to put this system in motion. The court's jurisdiction can be triggered in three manners. A state party may refer a situation where massive crimes appear to have been committed to the prosecutor. The United Nations Security Council, acting under Chapter 7 of the United Nations Charter, may also refer a situation to the prosecutor. This is already done, as we know, in the case of Sudan, Darfur. Or the prosecutor can initiate an investigation on his own motion. For the first time, the prosecutor has used this power in the case of Kenya. It is, however, important to note that neither a state party referral nor a United Nations Security Council referral binds the prosecutor into opening an investigation into a situation. The prosecutor must determine whether there is a reasonable basis to initiate an investigation based on criteria which is precisely laid out in the Rome Statute, which apply irrespective of the manner in which the investigation is triggered. These criteria are jurisdiction, admissibility, and in the interest of justice. With regard to jurisdiction, the Office of the Prosecutor assesses whether the alleged crimes are committed on the territory of a state party or they are committed by nationals of a state party. Whether these crimes have been committed after the entry into force of the Rome Statute on the 1st of July 2002, or later, if the relevant state has ratified later. And also, we consider whether the alleged crimes fall within the court's subject matter jurisdiction, which involves or covers crimes against humanity, genocide, and war crimes. With regard to the admissibility, we have a duty not, and I'm emphasizing not, to investigate when there are genuine national investigations or prosecutions pursuant to the principle of complementarity, of which I spoke earlier and which previous speakers have also mentioned. And this is why, for example, at the start of our activities, we decided to open an investigation in the Democratic Republic of Congo and not in Colombia. As opposed to the DRC, in Colombia, the authorities were and are conducting national proceedings against guerrilla leaders, paramilitaries, and politicians, political supporters, and in some cases, against members of the police and army. Furthermore, the statute requires that crimes reach a threshold of gravity. And another example is, the Office of the Prosecutor conducted a preliminary examination of the alleged crimes committed in Iraq by nationals of 25 states parties involved in the military operation there. We found cases of willful killings and torture, but they were not committed, and I'm quoting from the statute, as part of a plan or policy or as part of a large-scale commission, unquote. So we did not open investigation because the cases did not reach the gravity threshold established by the Rome Statute. And additionally, in all these cases, the states concerned we are conducting domestic investigations. Finally, in accordance with the statute, the prosecutor has the authority to decide not to proceed with an investigation or prosecution if it is not in the interest of justice. It would be exceptional for a prosecutor to decide that an investigation is not in the interest of justice and victims. The interest of justice must, of course, not be confused with the interest of peace and security, which falls within the mandate of other institutions such as the United Nations Security Council. The Office of the Prosecutor shall not be involved in political considerations. We have to respect scrupulously our legal limits. Your Excellencies, ladies and gentlemen, following this legal framework, we have opened investigations in the Democratic Republic of Congo, in Uganda, in Darfur, in Central African Republic, and in Kenya. 3 of these 5 situations we opened at the specific request of the states themselves, calling on the prosecutor to come and investigate, while the situation in Darfur was referred to the court by the United Nations Security Council. And besides our investigations, we are also monitoring a number of different situations in all regions of the world. The office is analyzing alleged crimes in Honduras, in Republic of Korea, in Afghanistan, and Nigeria. The office is also checking if genuine proceedings, national proceedings, are being carried out in Guinea, Colombia, and Georgia. And finally, the office is assessing the ad hoc declarations accepting the jurisdiction of the court by the Palestinian National Authority and by Côte d'Ivoire. In the various situations under investigations, we have had 6 cases enter into proceedings before the court, including our first case against Thomas Lubanga, who is charged with the war crimes of enlisting and conscripting children under the age of 15 years and using them to participate actively in hostilities in the Democratic Republic of Congo. And in the case against Jean-Pierre Bemba, as leader of the Movement for the Liberation of Congo, allegedly responsible for hundreds of rapes and pillaging in the Central African Republic. In addition, we have submitted with the judges of the court 2 applications requesting the issuance of summonses to appear for 6 individuals for their alleged responsibility in the commission of crimes against humanity in Kenya. Importantly, the court has also issued various arrest warrants which have not been executed, including against Joseph Kony and other leaders of the Rhodes Resistance Army and against President al-Bashir. All of them Africans. That is true. Why? Because the Rome Statute says that we should select the gravest situations under our jurisdiction, and also there are more than 5 million African victims displaced, more than 40,000 African victims killed, hundreds of thousands of African children transformed into killers and rapists, and thousands of African victims raped. The Rome Statute says that the court shall only step in when domestic authorities do not pursue accountability themselves. And in all the cases that I have mentioned here, all the cases that we have selected, there were no such proceedings. When the legal criteria are met, the Office of the Prosecutor shall open investigations wherever that is. The outstanding arrest warrants of the ICC show the importance of cooperation with the court and the need for engagement of a broad array of actors. There is need for consistent approach. The court might be the face of justice, but it is only, and I'm emphasizing this, it is only as strong as the commitment of states and the larger international community. Massive crimes require a careful plan. Certainty that these crimes will be investigated and prosecuted will modify the calculus of the criminals. Effective implementation of the Rome Statute crimes in domestic legislation will add to this certainty. Ladies and gentlemen, we have to realize that there is now a new international justice system. In Rome, states made a conscious decision to create a justice system that could stop or prevent violence rather than an ad hoc creation acting after the fact. New rules were created and other actors must adjust to this rule. Practice shows that the international community increasingly is understanding the role of the International Criminal Court. In Guinea, for example, immediately following the announcement of the prosecutor and the events of 28 September 2009 in Conakry were being examined, the Guinean Minister of Foreign Affairs visited the court on 2 occasions. Justice would prevail in partnership with the court. The court has sought to encourage and cooperate with national and international efforts to conduct genuine national proceedings, thereby ensuring that the commission of new massive crimes is prevented in new election periods. Similarly, the ICC prosecutor issued statements with regard to the situation in Côte d'Ivoire following the presidential elections in November of 2010, including warnings against inciting people to violence and putting individuals on notice. And in Colombia, the prospect of the ICC attaining jurisdiction was mentioned by prosecutors, by courts, by legislators, and members of the executive branch as a reason to make policy choices in implementing the justice and peace law, thus ensuring that the main perpetrators of crime would be prosecuted. And even before a judgment is rendered in the case against Thomas Lubanga, the issue of child recruitment has triggered debates in far-flung countries such as Colombia, which is a state party, but also in non-state parties like Sri Lanka and Nepal. Your Excellencies, let me conclude. Let me say this. This is the way forward. Our court, the ICC, will deal with only a few cases over the years, but the deterrent impact of its cases and rulings will extend to at least 114 states that are today parties to the Rome Statute. And it can even go beyond that to reach non-state parties. This is where the true relevance of the Rome Statute lies. It depends on political leaders. It depends on the military. It depends on diplomats and conflict managers. It depends on parliamentarians, victims, and ordinary citizens. We all have a central role to play. I thank you for your patience.
Honorables MPs, you are all primed up and ready to go into the interactive discussion to be able to pose your questions, and we are very fortunate to have in our midst the Deputy Prosecutor who you just listened to, and our Attorney General, as well as His Excellency Pacifici. We have earlier heard from him of what EU support has been like towards the ICC, and we also heard from the Justice Minister of Liberia, who has informed us that Liberia, actually President Attilo signed the ICC, the Rome Statute in 1999, and it was ratified by the interim legislature in 2004, and so Liberia have acceded to this treaty. And she also posed some questions which she addressed in her deliberation, and also clarified TRC recommendation versus constitutional rights, which have been appropriately ruled by the Supreme Court of Liberia. And then She also took into account the issues of culture, tradition, local idiosyncrasy, as she's put it, and other belief as Liberia proceed on the road to the Rome Statute and what government could do in that regard. So our Justice Minister is here to further entertain your questions, and we have the Deputy Prosecutor who have also informed us that the court is looking at the grievous of situation of crime, and the court is only focused on the interest of justice. Interest of peace and security remains with other organs of the United Nations, and the objective being to achieve a global justice system, albeit without a global government, and that is part of the challenge facing the RCC. And then she was very generous to throw the difference between the RCC and the various ad hoc courts, the Sierra Leone ad hoc court, the Yugoslavia ad hoc court, so that people can understand clearly the difference between the RCC, which is based on the Rome Statute, and these special courts which come into being as a result of United Nations and other initiatives. So, distinguished ladies and gentlemen, we also heard from the executive member of the PGA who threw light on the activities of PGA as relates to our own activities in promoting the ICC in line with the achievement of the Rome Statute. And so we will now entertain questions from you. And the procedure will be that if the honorable members can just put up their hands, and then when you are recognized, we'll pass the mic to you and you pose your question to the panel. If you have a specific question that you think you will need a question answer from a particular member of the panel, you are at liberty to so indicate. Yeah. And please, you should call your 1 minute. Please.
I am representative in the Ivorian National Assembly.
Je suis en même temps membre de la Commission nationale des droits humains en Côte d'Ivoire.
Same time, member of the Commission on Human Rights in Côte d'Ivoire.
Je voudrais très franchement et très sincèrement
I would like to frankly and sincerely
me réjouir de ma propre présence ici au Liberia.
Rejoice about my presence here in Liberia.
En dépit des difficultés de transport, parce que ce n'est pas facile de joindre le Libéria, même quand on vient tout près de la Côte d'Ivoire. Parce que j'ai le sentiment qu'une nation est en train de s'efforcer à renaître, est en train de s'efforcer à reprendre vie. Et j'ai foi en Dieu qu'une nation de paix et de prospérité, comme elle a été bien avant ces graves moments qu'elle a connus. Je remercie donc tous les députés, les membres du Parlement libérien qui nous accueillent. Et je voudrais que Dieu les accompagne et les bénisse dans leur œuvre de reconstruction du Libéria. Je voudrais dire, à la suite de ce qu'a dit Madame le procureur adjoint,
with respect to what the Assistant Attorney General of the Criminal Court has said,
que l'une des difficultés des partisans de la ratification que je suis, parce que je suis partisan de la ratification,
because I am partisan of the ratification my country has ratified,
et le fait que de temps en temps on s'interroge sur
from time to time
la sincérité et l'indépendance
the sensibility and the independence
de la Cour pénale internationale au regard de certains faits.
International Criminal Court.
Et je voudrais pouvoir prendre un exemple à partir de l'expérience de mon propre pays.
I would like to take an example from my own country, Côte d'Ivoire.
Parce que vous savez qu'aujourd'hui la Côte d'Ivoire est sanctionnée par le monde entier.
So you know that Côte d'Ivoire today is under the sanction of
le monde entier. Nous tombons dessus. L'Union européenne a sanctionné tous les dirigeants de mon pays. La CEDEAO est en train de faire mains et pieds pour qu'une force militaire aille envahir la Côte d'Ivoire. Je ne sais pas trop comment et pourquoi. Pourtant, il y a quelques faits simples que je voudrais porter à l'attention de tout le monde, mais que je sais que tout le monde sait. C'est en 2000, et je ne vais pas être très long, rassurez-vous. Voilà. que le président Laurent Gbagbo en Côte d'Ivoire a été élu.
President Laurent Gbagbo was elected.
En 2002,
in 2002,
alors qu'il était reconnu comme président par l'ensemble de la communauté internationale.
Why he had been recognized as president of the Republic,
le monde entier le reconnaissait comme président. En 2002,
in 2002,
un coup d'État.
Un coup d'État
dont les autres, en une seule nuit, ont entraîné plus de 300 morts dans la seule ville d'Abidjan.
This coup d'État led to the death of over 300 persons in one night.
Ni la CEDEAO,
neither ECOWAS,
ni l'Union européenne,
neither the European Union,
ni la France, ni les États-Unis,
neither France, the United States,
ni aucun autre membre de la communauté internationale n'a appelé à ce que les auteurs de cette tentative de coup d'État contre un régime reconnu on n'a jamais entendu un seul acteur responsable de la communauté internationale, y compris la Cour pénale internationale, la Cour criminelle internationale, a intenté la moindre action. Alors aujourd'hui, quand j'entends Madame le procureur adjoint dire
the Assistant Attorney General saying,
en citant quelques exemples,
was citing some examples.
Voilà. Et qu'en Côte d'Ivoire, la Cour a averti des acteurs sur les propos qui peuvent amener à des violations de droits humains. Oui, je veux bien. Mais qu'est-ce qu'elle fait déjà? Qu'est-ce qu'elle fait déjà des violations de droits humains qui ont eu lieu en Côte d'Ivoire? J'aurai le temps d'être long sur ma communication. Mais...
Je voudrais remercier les organisateurs de cette table ronde qui nous ont fait l'honneur de nous inviter à cette table ronde.
Thank you very much. I would also like to thank all the speakers and in particular the Deputy Prosecutor of the ICC.
N'a pas encore ratifié le traité.
My country, Ivory Coast, has signed the Rome Statute but not yet ratified.
On dit, ce qui a été dit par la Cour constitutionnelle de mon pays, c'est que certaines dispositions du statut de Rome ne sont pas compatibles avec certaines dispositions de la Constitution de la Côte d'Ivoire.
The Supreme Court of my country has stated that some provisions of the Rome Statute are not in line with the Constitution of Côte d'Ivoire.
Je suis un peu inquiet parce que depuis l'éclatement de la crise en Côte d'Ivoire, depuis le 19 septembre 2002 jusqu'à aujourd'hui, beaucoup de crimes se sont commis. Il y a eu beaucoup de crimes, il y a eu des atteintes graves aux droits de l'homme qui méritent aujourd'hui d'être signalés et qui méritent aujourd'hui que la Cour pénale internationale intervienne dans mon pays.
I'm a little bit worried about the situation in my country because since September 2002, many very grave crimes against human rights have been committed that deserve that the ICC steps in.
Countries, and how will this undermine the ICC? Lastly, but not the least, you said one of the conditionalities that you prosecute has to do with the interest of justice and not necessarily political or peace and security which is under the UN. My question is, the conflicts in most Africa in the countries, are actually overlapping when you look at maybe the reasons for those conflicts. Because sometimes you may have, it can be political and sometimes justice system and also peace and security. How do you discern, what is political, what is in the interest of justice or in the interest of peace? And how do you separate the contributions of these three in order for you to decide that a situation is political or issue of peace or security or purely in the interest of justice? And sometimes, who decides? Those are my questions. Thank you.
Thank you, Dr. Lahai. Senator Sherry?
Our Justice Minister and other parliamentarians here, we are very grateful to be here today, and we also like to thank the members of the Turkish government for the manner how they treated us in Turkey. I would like to say hi to our colleagues that we met in Turkey. We enjoyed our stay at the PGA. I listened very carefully to our deputy, and I'm wondering how are they coping with all the surrounding crises in our neighboring country, most especially the Ivory Coast. I'm very concerned about the Ivory Coast because it kind of borders with Liberia, and it kind of threatens our own peace and stability. And I'm also interested in knowing how the ICC has been able to work with our Liberian government as it relates to our forming part of the signing of the treaty in Rome, and how we can also, as Liberians, be able to propagate the idea of ICU and ICC. Thank you very much.
Okay. William, Deputy from Cote d'Ivoire. I think you first of all asked about what happened, where was ICC in 2000 when all these crimes was committed. The answer is simple. ICC was not in existence in 2000. That's, I think in my intervention, I did mention that ICC was created in 1998, and effectively in 2002, it was established after the required ratification. So ICC was not existing. And if you look at the temporal jurisdiction of the ICC, ICC is not retroactive. It will only try those cases when it became established in 2002. Anything that has happened or that has happened before 2002, ICC does not have the temporal jurisdiction to deal with it. So I think in simple terms, that is the answer to your question about your first question. But I also, Cote d'Ivoire has made a declaration, I believe in 2003 or 5. I think in 2003. In 2003, Cote d'Ivoire made a declaration under the Rome Statute accepting the jurisdiction of the ICC. Happened, or crimes that are committed in Cote d'Ivoire after 2003, because if you look at the declaration, there was no time limit. No time limit on the declaration. So all the crimes that were committed after 2003, the ICC can effectively and legitimately look into. Also talking about today, what the ICC has done. Based on this declaration that has been made, giving ICC jurisdiction, ICC has tried several times since then to come to the Cote d'Ivoire, to collect information, to talk to people. Unfortunately, for one reason or another, ICC was not, I don't want to say welcome, but the visit didn't happen, despite several efforts that we have made to come to Cote d'Ivoire, to look at following the declaration that has been made. In any event, still using this declaration and also using the preventive mandate of the prosecutor of the ICC, we have so far made several declarations regarding the situation in Cote d'Ivoire. I have to be very clear that none of the declarations that we have made so far is political. None of it is political, because this is not our mandate, and I have to be clear. We have a judicial mandate, and that is what we will exercise. But we have, the prosecutor and myself both, have made declaration asking the parties and persons to exercise restraint and not to commit crimes that would fall under the jurisdiction of the ICC. So far, this is what we can do. this is how we can contribute to preventing crimes from being committed. Because I think that you know, and I know, that crimes are being committed. Crimes are being committed, but we have asked that restraint should be exercised, that these crimes should not be committed. I do not think that any of these are political decisions. This is not our mandate. It's for others to do that. And we have left it to the others to do that. But what is in our mandate to do, we will do. And we will continue to collect information. We will continue to call on those who are inciting violence to stop it. And we will also continue to warn them that this incitement to violence can be a crime against humanity, or it can even be a war crime. So this we will, or in short, it can be a crime falling within the jurisdiction of the ICC. So far, this is what we can do, and this is what we have done. From also my brother from Cote d'Ivoire asking about the obstacles that we have, why we have not stepped in. The jurisdiction of the ICC is such that, as I explained, it's a court of last resort. It's not a court of first instance. Do or attempting to do anything. The choice now here is that either Cote d'Ivoire does it. If Cote d'Ivoire does not do it, ICC will do it. Impunity is no longer an option. You cannot go about committing crimes, killing people, raping women, doing all sorts of crimes and say nobody will do anything about it. I think those days are over. And these are the steps that we will take in Cote d'Ivoire. We will wait and see, and of course, all the opportunity will be left to Cote d'Ivoire. Let them do what they're supposed to do, but they have to do it. That's the bottom line. If they don't, then ICC will. The various visits to the ICC, or when the prosecutor announced initially that the crimes that have been committed in Guinea are of grave concern, and the ICC will be looking into whether those crimes fall within the jurisdiction of the ICC. As I mentioned in my presentation, immediately we had the minister visiting on 2 occasions, and I had the privilege of meeting him and discussing the crimes. I have also had the privilege of visiting Guinea and speaking with quite a number of actors in Guinea and authorities. My most recent one being just before the elections to call on the parties not to, to exercise restraint. This has been done, and Guinea has informed us, and they continue to update us, that a 3-panel judge, a 3-member panel of judges have been appointed, and they are working and they are looking into the crimes that have been committed. Complementarity again. Immediately, it kicks in. We have to wait and see whether those are genuine proceedings before ICC can go the next step. And we are observing that.
The United States of America, the country that is the leader of the free world, the country that aspires to the virtue of fighting against injustices, crimes against humanity, and what have you, is not a signatory to the Rome Statute. Was there any justifiable reason given for not being a signatory to that statute, or they do not believe in the justice system? What is there any reason given for which up to present I know they are cooperating with the court, they are providing intelligence in the area where people are committing crimes and what have you, but in my view that is not enough. So I want to know whether they stated any reason for not being part of this court. Thank you.
What intent you people have for those who have power to produce arms? Do you have any suggestion, punishment for them, or to include them, prosecuting them. Because we have power to fight, we're not scared to die. But we don't have power to even make collect our own. But the people who have power, when they face it, they don't use it on them, they use it on all. You people have any plan to address yourself to that? And then also, we willingly go to that, but when we die, you people sitting there prosecuting. You make more money, but the people who die, you not make any suggestion to compensate them. How you people going to complement
that? I just want to ask Madam this first question, insofar as the existence of ICC is concerned, and the existence of the special courts. I just want to know whether there has been an occasion where the two institutions met to review their activities, and what are some of the revelations you people had? If not, if the two bodies have in mind of doing so, because they all serve the same interest, but one is on an international basis and one on domestic basis. Second question also is, with regards to what my brother rightly said, most of the conflict or genocide activities come out as a result of inequalities insofar as national wealth distributions are concerned. And we Africans, we do produce primary commodities. Specifically, we are not above industrialization. And our communities are being determined by this international wealth, like my colleague was asking. They are not part to the signatory. What is the code doing in order to have equality in distribution or payment adequately for our product, so that we can use those resources to develop our people, so that this can cease? Thank you.
That's why they are not part of the court. They don't have to. No country has to give us any reason. No country. Because if you look at the ICC, as I said before, it's a treaty based on voluntary will of states. They want to ratify, they ratify. They don't want to ratify, they don't have to give any reasons why they don't ratify. Because it's a will. It's a sovereign will that is taken to sign and ratify, like with any other treaty. Like with any other treaty. You know, any other treaty, nobody forces any country or any state to ratify any treaty. Nobody. So in the case of the ICC also, if the states want to ratify, whether it's the United States of America, whether it's Cote d'Ivoire, whether it's another state that has not ratified, they do not have to give any reasons why they haven't ratified. And as an ICC official, I cannot sit here and look into the reasons why any country whatsoever does not want to ratify the statute. This is not my mandate. It's not. My mandate is to make sure that those who have signed and accepted the Rome Statute, they live to their obligations, and that it is all the execution of justice and planes, etc. At the Office of the Prosecutor, what we have instituted is to have what is known as the financial investigations, which will also encompass, those who are fueling, those who are providing the arms, those who are encouraging, those who are fueling the fire. These are the ones that we will look into. The Office of the Prosecutor has never said that we will not look at those, because all those actions that are being committed are crimes. So it still falls under our jurisdiction. It is very difficult to investigate, I have to say, and it needs a lot of cooperation. Not only from those who are manufacturing, but also those who are on the ground and are receiving it. So it's difficult, but it is not outside of our radar, and the Office of the Prosecutor is looking at it. You
If you look in
la communauté internationale,
that Guinea committed itself to the side of the international community
pour mener les enquêtes indispensables en vue de faire toute la lumière
in order to carry out investigation, in order to make to shed light
sur les événements dramatiques du 28 septembre 2009 dont parlait la procureure adjointe de la CPI.
On dramatic events to which the deputy prosecutor alluded to in his intervention.
À l'occasion desquelles des graves violations des droits de l'homme ont été perpétrées dans mon pays.
During this event, grave crimes were committed against humanity.
Pour ne citer que les plus récents.
Only to cite the most recent ones.
Et se fondant sur les conclusions des rapports des différentes commissions d'enquête mises en place.
To take into account the recent accords put in place
par le secrétaire général des Nations Unies,
by the Secretary General of the United Nations,
par le gouvernement de mon pays,
by the government of my country,
et par différentes ONG,
and by different NGOs.
Mon pays a saisi la CPI et le bureau du procureur de la Cour pénale internationale.
All of these things, but what are you doing to inform your citizenry about the Rome status? Thank you.
We live in a world where the old saying of might makes right still prevail at a large extent. For instance, in our own country, Liberia experienced a period of 15 to 16-year war. There were people who designed and supported the war. In an effort to bring peace to this country, the international community intervened. And through their intervention, we had the Accra Peace Accord, under which a system of justice was put in place called the Truth and Reconciliation Commission. That commission was created by statute of the National Legislature. The statute requires that the leadership of the country, specifically the president, shall ensure the full implementation of all a sweeping clause recommendation of the TRC. Unfortunately, after the TRC has submitted its report to the government became very selective as to which provision of the TRC recommendation would be implemented, contrary to the statute. Now, my question is, how can we, as a nation, achieve justice working along with the ICC, taking into consideration the Rome Statute, which also requires that those who are perpetrators of crime or supporters of crime that result into massive destruction and what you would call infringement of people's rights, specifically the right to life, the right to existence. How can the ICC be of a help to us, Liberia, in ensuring that the TRC recommendations are fully implemented so that we can have justice in this country? Thank you.
The effort to ensure that the standard of the ICC is also what is done in the member states. Because if you do not work to strengthen the legal system in the member states, you will be involved in a cycle of cure instead of prevention. So what are you doing to ensure that the ICC is working with the legal system in the various countries to have the kind of standard you expect. Now, I reduced that to my own Attorney General. Madam Minister, where are we with this whole thing about the ICC, and do we need to domesticate the local legislation to ensure that our legal system conforms to what we ratify? Are you satisfied with where we are? Thank you so much.
Questions? My question, Madam Minister, is it has to do with the constitutional ruling, the Supreme Court ruling, which you alluded to, and the TRC recommendations, and taking into account our culture and tradition, as you said it. My question is, being a full party to the Rome Statute, and confronted with a situation wherein our Supreme Court have ruled as such, and we have the TRC recommendation, do you foresee any obstacle where a situation to be presented wherein Liberia will have to cooperate with the ICC on any investigation that has to do with situation that occurred during our period of war that is covered under the ICC, since we are a party to it? Do you foresee any obstacle if such investigation were called for, especially so as regard a constitutional ruling and our being a party to the ICC? That is my own concern. So we will now go to our panelists to address these 4 questions. Can you take the lead?
I take the lead.
She take the lead.
The first thing I'd like to make categorically clear that the government is not selectively implementing the TRC. The government is interested in the report and has stated, the President herself has stated that she supports the TRC report. And I think what the public needs to know, and maybe some of our international partners as well, is that the Supreme Court did not condemn and declare the entire TRC report unconstitutional. It was a specific recommendation, and that had to do with a 30-year ban on political activities for those who were listed. And I think that particular list consisted of about 48 persons. The act itself was also not declared unconstitutional. There's an Article 48 that empowers and gives the TRC Commission the authority to take on judicial functions that was declared unconstitutional, because the legislature cannot give a body as the TRC Truth and Reconciliation Commission the judicial function. That's usurpation of the judicial branch of government. And so that's why that particular provision, that was the only one that was challenged. We don't know if there are other recommendations that may be challenged by citizens, but private citizens out there have the right to challenge something that affects them. An individual on that list challenged that because he was affected personally, and the Supreme Court ruled, I think, appropriately. The government could have gone in a direction where they fight to have the entire report declared unconstitutional, but that would have been contradictory to its own position that the report was very comprehensive and a good report, and that the government will do whatever it can to implement those recommendations that will promote the mandate of the TRC Act, which means that it will create peace, security, and reconciliation. There are other recommendations that are in the TRC report, as I mentioned in my paper, that are being implemented. One is the establishment of the Independent Human Rights Commission, in that the committee consisting of the Law Reform Commission, the Bar Association, the Independent Human Rights Commission, and the Ministry of Justice are now working on to put in place what they call the Palawa Hut concept. And we're moving on with other recommendations. So I think the government is making as much effort to promote those recommendations that will bring us together, because that was the purpose, to create peace and stability in Liberia. And those recommendations that divide us or that are unconstitutional in their implementation will not be implemented. I believe that most citizens will come and challenge those recommendations that they believe adversely affect their rights.
In Guinea. For us, we don't have any reason to doubt that there is sincerity in prosecuting these crimes, especially the crimes of 28 September. And just as you're advising, we have not stopped completely just because there is a new government. Because I think one of the key features of the situation in Guinea is that there is international consensus already not to tolerate impunity for these crimes. I think this is clear. At the national level, it is clear. Internationally, this is clear. And complementarity. You know, there is need, of course, to support this panel of judges. They have to feel supported. They have to feel that what they are doing for the national system is appreciated. Judges to the old government for this security and for logistical means and this support. And we are hoping and encouraging that the current government will also take this matter up and give the judges the support and both for security and logistics that they need. We are also encouraging, very encouraged by some of the signs that have been shown by the foreign embassies in Guinea, the US, the France, the EU, and even the UN. And support that is needed for them to carry on their work will be done. What we are doing, apart from encouraging these things to take place, is also to observe and to collect information and to exchange information to make sure that we know what is happening on the ground. So we have not left Guinea. We are still there. I think the subscription. By subscription. All the state parties who have signed and ratified pay subscription for the court to exist. And the second question I think has been answered by the Honorable Minister about the TRC. So I would rather not go there. It's not ICC's business, the route that Liberia takes to bring peace and stability to its people. Yeah. Kuntu, when ICC was established. I think I've said that here.
You got a cut-off point, brother. Okay. Bureau Senator Chair will give you that courtesy, please.
It was said that only when the state party makes a representation to the International Criminal Court, so there are three ways I think I understood you. So on their own, they can swat sponte. They said that, or the UN. So that's clear. So if your country does not make that appeal, and they feel convinced and compelled to do that, they will do that. Now, the TRC that we have reference to, and the Supreme Court opinion, there is a fundamental problem with the creation of the TRC itself in our country. Firstly, when you want to create a TRC, you suspended the Constitution. So those who wrote the TRC, who established it, at the time of making it, they did not take into consideration the provisions of the Constitution, of our Constitution. It is after the establishment of the TRC, the interim government passed a statute that you reinstated the Constitution. When you look at the provisions of the TRC, the act itself creating the TRC and the Constitution, they conflict. And our law says that any statute that conflicts with the Constitution is unconstitutional. And that is why you have the Supreme Court making this kind of pronouncement. But if the people have carefully looked at the provisions of the Constitution and carve the act creating the TRC, then perhaps we will not have this problem. But like the Attorney General said, and I have to make it clear to our nationals and our partners and our foreign guests that the TRC is being implemented because, like you said in Article 43, I think, that is why they said the final report and recommendation should go to the legislature. So because there are some laws that will be enacted to enable the president or anybody
to implement the provisions of the TRC. So I just like to make that clear here in this forum that the Constitution made it, the Supreme Court made some pronouncements based on our Constitution. And those pronouncements were made to resolve the problem of the creation of the TRC and bring it into full force the Constitution of the Republic of Liberia. Thank you.
Thank you.
Declaration, it was in October of 2003 that Cote d'Ivoire made a declaration accepting the jurisdiction of the court from 19 September 2002. This is what I referred to. And the only visit that we have been able to successfully make was in July of 2009.
Our Attorney General will not be with us whole day. She will be, so other questions will come in other section. But our Attorney General will make parting comments.
Thank you. I just wanted to say before I leave, for those who read the TRC report or heard about it, they do know that we have acts that were committed against the people of Liberia in 3 general categories, from the least offensive to the most heinous crimes. And all people who were named were not put in the same category. There were some people who were recommended for reprimand, and there are some people who were recommended for prosecution. So I just wanted to make that clear, especially for our international friends. I would also like to say that this government does not condone the unnecessary suffering of our people generally at the hands of other citizens and allowing that to go free. They're really, really very concerned about the atrocities that were experienced by our people, especially our young children who were so damaged. I see them every day in prison. I see people 16 years old who were 6 years old 10 years ago and who are confused about why they're in jail. And so these are things that are being considered, and these are things that are being addressed as we go forward. But there are certain things we need to do. We spend so much time on infrastructure development and re-establishing legal frameworks. We've forgotten that over so many years of suffering and Air Force experiences, our young people were not socialized properly. They lost a sense of value. Our social institutions broke down. I remember what happened as I grew up as a child. And I remember those things that were important. I remember being punished for not respecting other people's rights, not even respecting myself, and respecting other people's property. All of those things were lost in the war. They haven't been restored. We need to restore a sense of self-respect to our people and our children again. And I think when people respect themselves, they will develop strong, positive values, and they will understand what their rights are, and they will have the ability and the desire to pursue their rights. There are people out there who have been hurt, and they don't understand. We need public education. We need public education to tell people, to teach people to understand what happened to them, what is available to them in terms of redress of their grievances. We haven't done that. We're so busy building schools and building roads. Those things are important. But the minds of our people and the value system that we lost, we need to restore. Who's teaching our children? Who's telling them right and wrong, telling them right from wrong? Some of our children just going listlessly because they have parents who themselves don't know any better, who themselves take advantage of other people and disturb the rights and abuse the rights of other people. And this is a responsibility of all of us as parents and as government officials. We need to invest in psychosocial, and I keep telling the parents, the partners, I've told them that recently. I stopped asking, I still ask for logistics and all these other things, but I keep asking for social, psychosocial counseling. It seems basic, it seems simple, but it's so very important. Public education, public awareness. I learned a lot myself as Attorney General about the International Criminal Court. Our people need to understand about some of these international institutions and some of the local institutions. So we need to invest more in public education. And lastly, we need to strengthen our judicial system. We haven't done enough. Our mail is about to leave. What will happen in 2 years? What will happen in 3 years? Can we trust ourselves with each other? Have we done enough to feel safe that we can trust ourselves with the man across the street who had people to death 10 years ago? We need to ask ourselves that question. So we can't be rhetorical about anything around here. We need to be realistic. We need to strengthen the justice system so that our people will feel safe and fearless. So they will not be so fearful to come and tell us what their problems are, and so they will not be too fearful and distrustful to bring their complaints to us and depend on us, and to make sure that we provide justice for them. Too many times I have cases before me and I'm harassed by officials and non-officials who obstruct justice. That's their relative, that's their friend. No, you can't do this. You have to make an exception. There's no exception when we're talking about justice. We just need to make sure that we're just and fair in what we do. And if we don't take this seriously, 2 years down the road, we'll be begging the unmailed and the people to come back. We need to get serious, all of us as Liberian citizens and Liberian officials, and work with our international partners to help get ourselves from the abyss that we put ourselves in a few years back. And that's all I want to say before I leave. This blaming and accusing and all these political rhetoric are just completely unnecessary. We need to get realistic and get down to business, because the international partner will not babysit us and spoon feed us and carry us forever. We're supposed to carry ourselves at some point. And I always do what I can to show that we have responsibility and we have ownership. We cannot continue to depend on the international community to carry us. We need to get serious so that we don't go into another war and cause our children to lose their childhood. There's a group called the Presidential Young Professionals. They had a program on the beach, and they asked us to pair with them and to face them and to ask, they ask series of questions. But each time they ask one question and you interact with them, then they move to the next person and they ask another question. But there was a young man in front of me, and the question they asked at the time he stood in front of me was, what did you miss the most when you were growing up? And so when they asked that question, he was supposed to tell me, and then afterwards I answered the same question to him. And he looked me in the eyes and said, toys. I said, what do you mean? He said, toys. I used to wish to own a toy. I never had a toy. I was 4 years old when we went into the refugee camp, and all we were concerned about was food and safety. And as young as I was, 4 years old, I was concerned about food and safety. I never thought about toys, and by the time the war was over, I was too grown up to own toys. He said, so I spent most of my money, other than on food, I spent most of my money buying toys for my children, so they would not miss that. We don't want that to happen again. Thank you very much.
Okay, distinguished ladies and gentlemen, another round of applause for our panelists. You agree with me? Okay, I will ask all legislators in audience to please come for a photo with our distinguished panelists. From there, you go to your coffee break. And coffee break?
I think so. You have certainly.
Coffee break is just for 15 minutes, please. Please go to your left.
Had in terms of introducing legislation so that they can give effect to the Rome Statute of the ICC. All of the countries that are here today have ratified or become subject to the jurisdiction of the Rome Statute. But one of the challenges is that when you ratify, you still have to put the legislation in place. You can't just say, I agree to this treaty, but the MPs also have to put in place the legislation. And that sometimes is a bit difficult to take. It can be very time consuming. It takes up resources that may not be available. So really the reason why they are all here today is to sit down with each other and to find out how can we what's the best way, what's the easiest way for us to put in these implementation legislation in our different countries. Some of these countries have done some actions already. Some of them are still working on it. Another reason why we are having this meeting today is to allow an opportunity for legislators in West Africa to meet face-to-face with the Deputy Prosecutor of the International Criminal Court. I think we've had a very good morning, almost an hour and a half of just interactive dialogue, questions and answers with the Deputy Prosecutor. I think we all agree there's no substitute for hearing it directly from a person who is from the court itself, and I think it has helped a lot to clear up some confusion, answer some questions, give some clarifications as to what the court does, what it does not, and we're just pleased in my organization, PJ, to be able to facilitate that process.
Why is it a
key issue, not just to me, and not just to countries here in West Africa and Africa, but it's a key issue to countries in Latin America, it's a key issue to countries in Asia, and there's really one reason why. Because many countries, unfortunately, even in the times that we live in today, have suffered terrible atrocities and terrible crimes. Liberia is one country, Sierra Leone is other country, but these crimes have been committed in other countries and in other continents as well. So the one thing that they all have in common is a deep, deep wish to make sure they never happen again. And that's why the ICC is so important. We heard the Deputy Prosecutor this morning talk about how the court can be a deterrent effect, a preventative effect. And I think what she meant by that was saying, just by our people, everyone knowing that the court exists, it makes them think twice before they engage in the sort of crimes that they know that for the first time, hold on a second, if I commit these crimes, there's a real chance I'm going to be prosecuted, I'm going to be investigated, I could be thrown in jail. Whereas before, that didn't really exist. And so now, for the first time, the court is there. The court, first and foremost, and again, the Deputy Prosecutor said this earlier today, the court wants national courts. It wants the courts in the different countries to do the prosecutions. But in cases where the courts can't, in the countries themselves, if they're unable or unwilling to do that for different reasons, then the ICC will come in. That's what the Deputy Prosecutor said about Côte d'Ivoire this morning. You were all here. She said, we want you in Côte d'Ivoire to take responsibility for prosecuting the people who may have committed these crimes. But if you aren't able to do it, if you're unwilling to do it, we will do it. And so our main hope and our goal, and the goal of everyone around the world, is we come from different countries, different regions, but we all have one goal. We want to live peacefully. We don't want these terrible crimes to be committed.
So the situation in Liberia, you have a list. I'm sure you have.
The TRC is also an issue that we've discussed here this morning. The Minister discussed it and dwelt on. We're not here to take up the matter of the TRC. Now, that may surprise you a little bit. It may even disappoint you a little bit. But we are here, as you can see from the banner behind me, to discuss implementation of the Rome Statute of the ICC. The issue of what has happened here in Liberia, and we all know very, very well what has happened in Liberia, the terrible crimes that have been committed, that is a matter for the people of Liberia to deal with themselves. One clarification that was also made today was that the International Criminal Court cannot have any role insofar as those crimes that have been committed here in Liberia. And there's a very simple reason for that. That reason is because all of those crimes took place before Liberia joined the International Criminal Court. And the Criminal Court only prosecutes crimes after a country becomes a party to the Rome Statute. So if Liberia ratified the Rome Statute in 2004, all those crimes, those terrible, terrible crimes that took place here, they had finished. They were that civil war of 1999 to 2003. So there's no scope for it. But here's where the ICC can make a contribution in Liberia. Because you are party to the... Liberia ratified the Rome Statute because, like other countries, the 114 other countries all over the world that have ratified, they don't want it to happen again. It's about, they don't want it to happen. So no, we are not here. Although, of course, it is extremely important. We are not here to take up a matter which, while extremely important, is not a matter that my organization deals with directly.
So how many countries or personally have or passed legislation when it comes to this RCC, the support this RCC?
How many countries
that has passed legislation?
Okay. 114 countries have become party to the Rome Statute. But and it's a source of some concern, not as many countries as we would like have done the next final and key step, which is to put the legislation in place. Around the world today, of the 114 countries that have ratified the Rome Statute, no more than approximately 35, possibly 40 countries have taken that final step, put the implementing legislation in place. I'm happy to tell you that some of the countries that have done...
Are these some of the challenges facing the...
President Bush and Prime Minister Blair?
Yes.
Vice Chair of the PGA National Group in Sierra Leone and a member of the opposition in Parliament, Honorable Musa Shaka Sana, you can please take the podium.
The Deputy Prosecutor, International Criminal Court, Madam Fatou Bensouda, distinguished delegates, ladies and gentlemen, I'm greatly honored and privileged to make a statement on behalf of the Chairman, PGA Sierra Leone, the Honorable Soufiane Kagbo, who is unavoidably absent and would have loved to be with us at this regional roundtable discussion on the implementation of the Rome Statute of the ICC. Mr. Chairman, the sheer scale of the horror committed during the rebel war in Sierra Leone made Sierra Leoneans brutally aware of the evils of war and the need to call on leaders to account for planning and creating atrocities. Our unstable and violent past has built in us a strong commitment to play a leading role in the advancement of global peace through an internationally administered justice system. Sierra Leone signed the Rome Statute on 17th October 1998 and ratified it on 15th September 2000, becoming the 20th state party. In 2002, the Special Court of Sierra Leone, SCSL, was established through a bilateral treaty between the Republic of Sierra Leone and the United Nations Organization to try those bearing the greatest responsibility for serious violations of international humanitarian law and Sierra Leonean law committed in the territory of Sierra Leone since 30th November 1996. Our cooperation with the ICC and the establishment of the Special Court on Sierra Leone are clear indications of our genuine commitment to the development of the rule of law and the application of international law. The Special Court in Sierra Leone was a remarkable step forward in the fight against impunity and provided the opportunity for people affected to see justice being done in their presence. Sierra Leone has also signed a number of other multilateral human rights and rule of law conventions or statutes, including the protocol creating the Community Court of Justice for members of the ECOWAS, International Covenant on Civil and Political Rights, the Convention on the Elimination of All Forms of Discrimination Against Women, and the African Charter on Human and People's Rights. Mr. Chairman, distinguished delegates, Sierra Leone as a country recognizes the crucial role of national jurisdiction in the prosecution of the perpetrators of the most serious crimes, including genocides, crimes against humanity, war crimes, and the crime of aggression, which continue to happen around the world. The domestication of the Rome Statute into our respective national laws is crucial, since the statute relies on the principle of complementarity, which means that the ICC is only authorized to act when states are unable or unwilling to intervene when crimes of international nature are committed. State parties are therefore obligated to investigate and prosecute serious crimes over which the court has jurisdiction. After ratification, the domestication of the Rome Statute was faced with a number of challenges. The Constitution of Sierra Leone 1991 requires that international treaties or commitments, such as the Rome Statute, need the enactment of implementing legislation. As a country emerging from a devastating war, we were confronted with competing priorities and was therefore not immediately able to prioritize implementing legislation after ratifying the Rome Statute. I'm glad to report that the draft bill on the Rome Statute is before the newly appointed Attorney General and Minister of Justice, who coincidentally was the former chairman of Manifesto 99 and championed the drafting of the implementing legislation. It is expected that the draft bill will be open to civil society scrutiny and input once it is approved by Cabinet prior to being tabled in Parliament. The PJ National Group is closely collaborating with a coalition of civil society on the International Criminal Court to fast-track the domestication of the Rome Statute. A committee has already been set up to draft a memorandum of understanding between the PJ National Group and the coalition. The MOU is expected to be signed soon. The dissemination of information to stakeholders, including lawyers, judges, the police, and the civil society as a whole, also poses a major challenge. Stakeholders need to be informed, particularly on the nature and elements of the crimes of genocide, crimes against humanity, and war crimes, and the crime of aggression when it will have been defined. The stakeholders should be given adequate information on such important legislative move, as they will be eventually affected as victims, indictees, investigators, witnesses, prosecutors, defense lawyers, etc. Hence, there is an urgent need for mass sensitization or seminars throughout Sierra Leone to disseminate information to stakeholders. This will require closer technical, financial, and moral collaboration between the PJ National Group, PJ International, the government of Sierra Leone, and non-governmental organizations involved in efforts to domesticate the Rome Statute in Sierra Leone. I affirm our commitment as a country to always contribute our fair share in building a sustainable global peace. Thank you for your kind attention.
Just for information, the Uganda review meeting last year has actually dealt crime of aggression. And now, we know exactly what was agreed in that meeting. And I will ask that for those who may not know, we will contact the necessary websites, or PJ is also in a position to give us what was agreed in that review meeting. I thank you, Honorable, for that. I will go on straight to Honorable George Kuntu Blankson, Member of Parliament from Ghana. He is also the Majority Chief Whip in the House of Parliament. Honorable Blankson.
Thank you. Thank you, Madam Chairperson. Honorable Chairperson, honorable colleagues from other parliaments, ladies and gentlemen, all protocol observant. I thank you very much for this unique opportunity to make these few remarks on Ghana's position on the ratification of the Rome Statute on the International Criminal Court. Madam Chairperson, permit me to convey to the forum the warm compliments of the Speaker of Parliament of Ghana, Right Honorable Joyce Bensouda, and the entire membership of the Parliament of the Republic of Ghana. The idea of a permanent international criminal court was conceived of with the aim of establishing a court with universal membership coupled with the mandate to exercise universal jurisdiction, thereby ensuring that no individual in any state will be left behind or beyond the reach of international criminal justice. This therefore demands that we sustain the efforts at attaining the goal of universality of the Rome Statute. If the progress made at the Kampala Review Conference is to be consolidated before and after 2017, Ghana as a party to the Rome Statute has strived and worked tirelessly towards the achievement of this goal through its permanent mission in The Hague and New York. Honorable Chairperson, permit me to quote a position what was said by our former Attorney General, Mrs. Betty, and I quote, Ghana is pleased with to be participating in this conference, first review conference, which offers an opportunity to reaffirm our commitment to fighting impunity by ensuring individual accountability for the most serious crimes of concern to the International Court, namely war crimes, crimes against humanity, genocide, the crime of aggression through adherence to the values and principles of Rome Statute, unquote. In our view, the principle of complementarity, which says that the ICC shall be a court of last resort when competent national jurisdictions are unable or willing to act, means combating impunity and ensuring individual responsibility should start at home while being equal concerned about the situation beyond our borders. Madam Chairperson, Ghana has decided to reactivate the National Interagency Task Force for the implementation of the Rome Statute. Among other things, the task force will review the necessary step to incorporate the Rome Statute into the municipal law, giving due consideration to the need to conclude cooperation and enforcement agreement with the ICC, as well as ratifying the agreement on the privileges and immunities of the ICC. Incorporating Rome Statute in the domestic jurisdiction will help harmonizing standards for prosecution in national jurisdictions. The government of Ghana, in collaboration with Parliament, shall endeavor to accomplish this objective by the end of this year. Madam Chairperson, Ghana is mindful of the fact that the Rome Statute is basically aimed at individuals responsible for perpetrating the most serious crimes of concern to international community. However, even the best of intentions, the reality is that given resources, including time constraints, it will be difficult for any court to bring all perpetrators to justice. This reality speaks of need to pay attention to preventive measures by addressing the root causes of some of these crimes. In African Union, Madam Chairperson, the principle of non-interference, which is expressed in Article 4 of the Consultative Act as the right of the Union to intervene in a member state in cases of war crimes, crimes against humanity, and genocide, as well as the peer review mechanism, are some of the tools intended to deter and prevent such crimes and promote the rule of law. Thus, our effort to call on alleged perpetrators to account must go hand in glove with technical assistance to improve the capacity of national authorities not only to prosecute but to prevent Rome Statute crimes. At the 9th Assembly of the State Parties to the Rome Statute held in New York from 6 to 10 December 2010, Ghana's delegation again reiterated Ghana's stand on the domestication of the Rome Statute into our municipal law. Ghana, with other state parties, ratified and adopted the definition of crime of aggression and other amendments adopted in Kampala. Ghana concluded her statement by calling on the state parties to uphold and accord equal attention to all the key pillars and principles underpinning the Rome Statute. These are complementarity, cooperation, and the independence and impartiality of the court. There is also the need to sustain the momentum in promoting the universality of the Rome Statute. Madam Chairperson, the Memorandum to International Criminal Court Bill of 2009 is a crystallization of the Ghana stand on the Rome Statute. Copies are available. The objective of the bill states, and I quote, "The objective of the bill is to give effect to the implementation in Ghana of the provision of the Rome Statute of International Criminal Court, ICC. We have come a long way since the signing of the Rome Treaty in 1998 and consequently of the International Criminal Court in 2002. The success so far made attained could not have been possible without the untiring effort of individuals, groups, civil society, and the president officials of the court, who have dedicated themselves to the cause of international criminal justice into the fight against impunity. This, Honorable Madam Chairperson, is the stand of Ghana. Thank you all for your attention, and may God bless you all.
Thank you very much. These are men that actually, they listen to women, not so, because they've both done it in 7 minutes. So the challenge is now yours, Honorable. And I want to thank Honorable.
À cette saisine, le Conseil, par une décision, a jugé le dit statut non conforme à la Constitution du 1er août 2000.
On the first day of the Constitution of Ivory Coast.
Les articles du statut de Rome qui sont non conformes sont précisément les articles 17, 52 et 99 du statut de Rome.
The clauses that were not incompatible with the Constitution of Ivory Coast are the 17, 52, and 56. Sorry, 57 of the Statute of Rome.
Ainsi, pour aller vite, je voudrais préciser que l'État de Côte d'Ivoire est donc favorable à la ratification du traité de Rome, sauf que pour pouvoir ratifier ce traité, il faut au préalable opérer une modification de sa constitution.
I must state clearly that the government of Ivory Coast is willing and is interested in having this convention ratified, except that it will have to amend its own constitution.
Or, la situation de crise que connaît le pays depuis le coup d'État de 1999 et qui perdure jusqu'à ce jour rend impossible en droit une révision de la Constitution.
But it's except that since the coup d'État of 1999 and the following crisis, the crisis that ensued, it has been very difficult for the government of Ivory Coast to be able to provide the necessary mechanism for the ratification of this convention.
Pour contourner cet obstacle, le président de la République de Côte d'Ivoire
the President of the Republic of Ivory Coast
a fait une déclaration de reconnaissance des compétences de la Cour
made a declaration relative to the acknowledging the authority of the statute.
Le 18 avril 2003.
April 18, 1993.
En souhaitant que la Cour vienne enquêter sur toutes les violations des droits humains commises depuis son entrée en vigueur.
So that the International Court of Justice will come and investigate all matters of crime that have been committed in Ivory Coast.
Donc, la déclaration de reconnaissance de compétences de la Cour pénale en Côte d'Ivoire.
This declaration recognizing the competence of the international court
pourrait être assimilé à une ratification ad hoc du statut de Rome.
Understood as an ad hoc ratification of the statute. The political success of the Rome Conference in July 1998
n'a été qu'une victoire partielle qui doit devenir une grande victoire pour l'humanité.
Was a partial victory which should become a great victory for humanity.
Pour rendre manifeste cette grande victoire,
in order to show the manifestation of this victory,
il ne faut pas négliger de ratifier le statut de la Cour pénale, car ce serait lancer un message négatif à l'ensemble de la communauté internationale.
We cannot neglect the ratification of this statute because it will be sending the wrong message to the international community.
Le gouvernement ivoirien, le Parlement ivoirien,
the government of Ivory Coast and the Ivorian Parliament,
malgré quelques inquiétudes, sont engagés dans cette voie.
In spite of some worries are actually engaged in that trend.
Celle de doter l'humanité d'un instrument de justice.
That is to give the international community a tool for justice.
De lutte contre l'impunité et la promotion de la dignité humaine.
The fight against criminality and the promotion of human dignity.
Et de respect des droits humains.
And the respect of human rights.
C'est pour cela que le Parlement ivoirien voudrait remercier tous les organisateurs de cet atelier.
That's why the Ivorian Parliament would like to extend its thanks to all of the organizers of this forum.
Et marquer.
And underscore its willingness to participate of all of the things that will be there.
Pour faire de cette cour une réalité concrète dans tous les pays du monde.
in order to make this statute a reality in all of the countries of the world.
Il s'engage
Parliament engages itself
à procéder dans les meilleurs délais à la révision de la Constitution
to engage itself in a process that will lead to the ratification of the convention in the shortest possible time.
Pour permettre la ratification du statut de Rome.
In order to have it ratified by the government of the Ivory Coast.
Je vous remercie.
Thank you.
Thank you, Ms. Gabriel, to stay in his seat and make this presentation. Yeah, represent us. What is coming out clear at national level, both at the level of the executive, the judiciary, and the legislature, to implement the Rome Statute. And of course, it's also coming out the issue of constraints, certain issues that are constraining the fast implementation or domestication of these statutes. What we will now do is to give 5 minutes, we are running out of time, for burning questions or burning comments, but we'll limit it to 1 minute per person. And I mean 1 minute.
From the Liberian Parliament. My question goes to the distinguished parliamentarian from Ivory Coast. If I got the Deputy Chief Prosecutor well, she said that Ivory Coast has made a declaration with respect to her support to the Rome Statute. And I listened to the honorable parliamentarian who said that Ivory Coast has a goodwill. The desire is there to ensure that this is ratified, but it is not yet ratified. So what I would like to understand that under this condition where a declaration of support has been made, but yet it has not been ratified by the parliament of that country, is it possible that a citizen of Ivory Coast who commits a crime that is recognized under the Rome Statute, which places it under the jurisdiction of the RCC, can that person be answerable before the RCC? That's my question, please.
Liberia Parliament. My question or suggestion to Madam President, please be attentive.
I hope the prosecutor is taking notes of some of the questions.
Okay. Okay, the prosecution.
Can she please?
The happy, let's say Africa's Leone, and this I know person woman who you can't live long. But one of the limits, they code, 20 code, the Blanc code, Africa, Guinean code, and to not be trying their own country, they go trying here. To make it into two. West Africa code of criminal justice or South Africa to have two code only to increase their, maybe the membership, so that they can do the speed, because it's called the greater, after the peace, after the war, the peace comes, then you'll be useless. So one now we can, the prosecutor to come put it into consideration that it will have two codes in Africa. That means if you commit criminal under the West Africa, you know how to go one code so they can come with issue of jurisdiction. So that's one question. I don't know what you will be thinking on that feature.
In connection with the presentation made by our colleagues from Ivory Coast, in his presentation he made it clear that under their law, according to the constitution of the Ivory Coast, any treaty that is entered into, that treaty can only be binding on the people of Ivory Coast if it goes through the process of ratification. He went on again to say Ivory Coast has gone to work and recognized the jurisdiction of this court. Meaning that yes, Articles recognizes the court, but Articles has not ratified the statute in accordance with its constitution. So I bring back the question asked by my colleagues. Under this condition, can a citizen of the Republic of Ivory Coast be liable in front of this criminal court?
You have now, apart from your national jurisdiction, you now have an international jurisdiction to be able to deal with crimes. Such that if you do not deal with these crimes, either you are unable to deal with them or you are unwilling to deal with these crimes, then you are saying effectively, by being a state party, ICC, you can come in and try this case. So that ICC is a court for each and every state party that has signed and ratified the Rome Statute. And now today, if 31 African countries have signed and ratified the Rome Statute, do you think that there is any logic in now trying to get other courts when you can make use of the ICC as your own court and work with the ICC? What is going to be the difference of creating another court, which maybe you will find a reason of not cooperating with it, because perhaps you are unable or you are unwilling? So these are the things that we need to look at. And secondly, when you look at the ICC statute, it does not necessarily say that it only sits in The Hague. The first article of the ICC tells you that it can sit anywhere. Anywhere. So, for example, it could move and sit in the Democratic Republic of Congo. And we did try, in fact, to do that. We requested Congo that we wanted to move the court to sit in Congo. But Congo came back to say that for reasons of security, they do not want the ICC to sit there because they will not be able to manage it. So this has to be clear, that the ICC is not a court in the West, by the West. As I continue to emphasize that 31 African countries are members of the ICC now. So I think we need to look into that and make better use of ICC instead of creating other ad hoc courts or trying to do something different. The aim of the ICC is to make sure that national systems work. If national systems are working properly, ICC may not even have cases, because that means that the national systems are taking their primary responsibility to investigate and prosecute. I think these are the things that we need to look at instead of duplicating the wonderful work that we have done in Rome.
Or sharing with us the various works they are doing in their respective parliaments or in their respective countries with regard to implementing the enabling legislation. Let me end this session by a quote from a very famous NGO activist recently in the Heads of State meeting. This is what he had to say. His alien time. He said, neither the African Union nor Africans deserve a leader whose regime is notorious for abuses, corruption, and a total disregard for the welfare of its people. So I think a word for a wise is sufficient. You don't want to face the ICC, then meet your social responsibility to your people. That ends it. Nothing more, nothing less. Otherwise, one day you face the full penalty of the law, either nationally or internationally. I thank you very much.
The delivery system, and these money ended in the pocket of a handful of people. So when they came in, they compared the government of Liberia through the national legislature to institute to come up with enabling legislation that will compare the vast majority of our people in benefiting from the resources. The forest management law was passed.
Right after the forest management law, the community right law was also passed. The community right law is the law that empowers a person to go in a community, bid for a forest, and organize a concession. The law requires that to go in that community and embark upon any concession venture, you must sit and discuss with individuals in that community so that they too can have their input. We passed that law, we work with that law. Today, the ban is lifted on forest product. Another consideration was that your army did not know the rules of engagement. As a result of that, when the country went to war, instead of the army protecting the citizens of the country, the army went against the citizens, and violated their human and constitutional rights. Now that you have come to the end of the war, pass a legislation to ensure that your whole security sector undergoes a kind of reform that will meet international standards. The National Legislature of the Republic of Liberia, in collaboration with the President of the Republic of Liberia, succeeded in passing this legislation. And as I speak to you, the security sector is undergoing reforms to meet up with international best standards. I'm giving you these historical highlights so that you will be able to understand that since the coming into being of the government, we have been working assiduously to create institutional frameworks in which the laws will be adhered to, so that there will be no need for any violation that will lead any Liberian government official to the International Criminal Code. And it is along this line, I agree with the Deputy Chief Prosecutor, that once you create the enabling environment to meet up with the basic necessity of life for your people, there will be no need to go to any International Criminal Code. The International Criminal Code was created purposely. During the creation of that code, I was then in the House of Representatives when the statute was first drafted and introduced. By then, I was chairperson on the Committee on Judiciary, Claim Petition, and Human Rights. Councillor Galawolo from the Senate by then and myself attended the first conference. We came back and made a report to the 51st legislature, and our opinions were sought as to whether or not Liberia should affix its signature to that statute. And we advised the legislature at that time, the 51st legislature, that indeed Liberia does not exist in isolation of the global community, and the attempt made by the global community to bring this code into being is intended to afford everyone justice. So we gave the advisory opinion, and later on the charter, the statute was signed. The statute was later ratified in 2004 following the Accra Comprehensive Peace Accord that brought into being the National Transitional Government of Liberia under the chairperson of Chairman Julie Bryan. Julie Bryan approved the ratification, and today Liberia is a bona fide subscriber to all of the tenets of the International Criminal Code. But as parliamentarians, what do we do to help this code in meeting its goals and objectives? We must be able to produce appropriate legislative framework
for the establishment of national human rights institution, and this institution must be established in accordance with the principles and guidelines listed under the Paris Principle. We should also exercise our respective oversight responsibility by constantly interacting with these human rights institutions so that we will be able to know the issues that are confronting them. These international human rights institutions, national human rights institutions, must be further complemented with the enabling legislation so that in the discharge of their duties as independent human rights groups, they will not be able to compromise their functions through any government influence or what have you. The committee of our respective parliament must also conduct periodic hearings so that they will be able to understand the respective human rights situation in our country. So in a nutshell, Mr. Moderator, what we are seeing is that plans are underway to ensure that the Rome Statute is domesticated. But we are first of all doing it through the creation of the requisite institutional framework, such as the Independent Human Rights Commission that we have created. We have 7 persons assigned to that commission. We gave that commission an independence to investigate the findings of the Truth and Reconciliation Commission and to come up with the appropriate recommendation. When that commission conducts its finding and recommends to the national legislature that in order to prosecute this crime, to prosecute the other violation, the legislature must come in to create this court or this tribunal. We want to assure you that the legislature of Liberia will promptly do that. Thank you very much.
Thank you. Well, that was the Honorable Gabriel Massally of the Liberian Senate, outlining the basic principles of implementing legislation, complementarity, and the general principle. And he said that first he outlined the problem, the root causes of the problem in Liberia.
Je voudrais, à l'entame de mes propos, dire que le Mali a ratifié et signé, et a signé et ratifié le statut de Rome.
I want to note already that my country, Mali, has already ratified the Statute of Rome.
Je voudrais également, comme le temps est très limité, de souhaiter les vœux, le bonheur, de justice, parce que nous parlons de justice, et sur cette table ronde, il est impératif qu'on parle de justice et qu'on se souhaite justice.
Because of limited time, I would just like to wish to all of you a goodwill, and also wish you to all of us to want to promote the sense of justice. As in fact, we are talking about justice, and that is very important and crucial that we talk about it.
Toutefois, beaucoup de travaux ont été faits par rapport à la relecture du statut de Rome, et surtout ce qui a été fait au mois de mai dernier en Ouganda.
Many works have been accomplished relative to the Statute of Rome, particularly that which was done in Uganda in May 2000, May last year.
Dans mon pays, il est impératif de vous dire que la notion de complémentarité et de la coopération avec la Cour pénale reste à revoir parce que nous n'avons pas encore fait ce travail.
I just want to state here that the concept of complementarity and cooperation with the ICC is still under review, and we are trying to take a serious look at that in Mali.
Les crimes pour lesquels font l'objet du statut de Rome sont déjà pris en charge par le livre 3 des articles 29 et 32 du Code pénal au Mali.
In Mali, especially in our penal code in section in articles 19 and 23.
Donc les travaux qui vont constituer la coopération, c'est un travail de longue haleine dans la durée.
What we have to do with this complementary cooperation is a very long process, and so we just need to be persistent.
Tout état de cause, faire fonctionner la CPI sans ces deux éléments, c'est vouloir faire des omelettes sans casser des œufs.
In any case, for the ICC to be very functional without those two elements as a complementarity and cooperation, it is just like making omelets without with the fear to break eggs.
La complémentarité et la coopération sont à la CPI ce qu'est l'eau pour le poisson.
These two elements are just to add to the ICC, just like the water is to fish.
Donc il y a des difficultés dans ce travail. Moi je voudrais à cette tribune d'inviter les parlementaires à sensibiliser dans les différents parlements pour faire passer ou sinon modifier pour que le statut de Rome puisse être une réalité sur notre continent.
There's a hard work to be done. I just want to wish to all of you as the parliamentarians to make sure that these things are done in order to give the ICC to be functional.
Ce qu'on doit nourrir ici, c'est que la CPI n'est pas contre quelqu'un. La CPI est pour nous tous.
What we need to know as a people is that the ICC is not against any one individual. It is for the good of all of us.
Donc mes propos vont se limiter ici en s'engageant de dire que à mon retour, je vais m'investir en ma qualité de président du groupe PGA de faire ces travaux dans la dignité pour que chacun puisse vraiment savoir qu'au Mali, il y a le groupe PGA qui est là pour faire ce travail.
So I will end my intervention by just saying that as a leader, as president of the GAP, the PAG rather, PAG in Mali, I'm going to ensure that everything is done in order for these two elements, these works to take place, so that Mali can also help to push things forward.
Une fois de plus, je remercie le Liberia de nous accueillir vraiment sur cette terre d'accueil, d'hospitalité. Et je vous dis merci, merci beaucoup pour toutes les questions qui ont été posées ici et toutes les interventions positives que nous avons eues. Je vous remercie.
Merci beaucoup, to thank Liberia, I would just like to thank Liberia for receiving us here, our hospitality, for all the questions that have been asked here, for all of the interventions that have been made here in this country, so that the ICC can move forward. And thank you very much for allowing me to take part in this forum.
Eyeball David Gomez. It's all yours.
Monsieur le Président,
Mr. President,
honorables parlementaires,
honorable members of the legislature,
les derniers intervenants ont deux avantages.
The first people to intervene have two advantages.
Celui de récolter les minutes perdues laissées par les autres.
That is to take gain of the minutes that are left out by others.
Et tirer parti de leur expérience.
And then to draw from their experiences.
Mon troisième avantage est que j'ai un président au lieu d'une présidente de séance.
My second advantage is that I have a me as a moderator and not a lady.
Il est peut-être moins strict que les femmes.
It's less stressed.
C'est pour moi un plaisir de prendre la parole au nom de mon pays.
It's a great pleasure that I'm addressing this forum on behalf of my country.
En République de Liberia que je connais très bien.
Here in the sister Republic of Liberia that I know very well.
Si proche de la Guinée sur plusieurs plans.
Very close to Liberia in many regards.
Ainsi qu'au nom du Conseil national de la transition que je représente au sein de cette auguste assemblée.
And in the name of the transitional government that I represent in that August body.
Conseil national de la transition.
The transitional, National Transitional Assembly.
Pour prendre part à la table ronde destinée à l'examen de la mise en œuvre du statut de Rome.
To take part in this roundtable, which will lead to the implementation of the Statute of Rome.
De la Cour pénale internationale.
The ICC.
À l'initiative de l'Action mondiale des parlementaires.
Initiated by the Global Action for Parliamentarians.
Je voudrais m'acquitter d'un devoir.
I would like to carry on a specific task.
Celui de vous transmettre les salutations du professeur Alpha Condé.
That is to transmit to you the greetings from Professor Alpha Condé,
président de la République de Guinée,
the President of the Republic of Guinea,
et de Madame la Présidente du Conseil national de la transition,
and Madame the President of the
National
Transitional Legislative Body. Council.
Diarra
Diallo,
mais aussi mes remerciements personnels.
And also my personal thanks.
Et ma profonde reconnaissance pour l'accueil.
And my acknowledgement of the reception.
Et toute la considération que vous avez réservée à mon pays.
And all the consideration you are giving to my country.
Depuis que je suis là.
Since I came here.
Je voudrais vous parler brièvement de ce qu'est le Conseil national de la transition.
I'm going to tell you briefly what is the Transitional Council.
Les accords ont été signés à Ouagadougou.
Accords were signed in Ouagadougou.
Le 15 janvier 2010.
January 15, 2010.
Et ont établi les bases légales d'une sortie de crise apaisée.
And this gave rise to the coming to existence of this Transitional Council.
Les trois organes ont été mis en place à cet effet.
There's three structures that were put in place for that reason.
Le président de la transition.
The president of the transition.
Le gouvernement de la transition.
The transitional government.
Et le Conseil national de la transition.
And the National Council, Transitional Council.
À ce jour, seul ce dernier organe existe.
Right now, it is only the last structure that is still functional.
Le conseil auquel j'appartiens devait suppléer à titre provisoire à l'Assemblée nationale.
This transitional council were meant to replace in a temporary way the parliament.
Son rôle et sa mission, c'était de réviser la Constitution.
He has a function, he has a role to review the Constitution of Guinea.
Réviser le code électoral.
To also revise the electoral code.
Élaborer des lois organiques.
Formulate organic laws.
Pour définir le cadre juridique approprié pour les élections présidentielles en 2010.
In order to define the legal framework leading to the elections, the presidential and general elections in Guinea in 2010.
Comme vous le savez tous,
as you all know,
l'élection présidentielle a déjà pris place.
The presidential elections are already taking place.
En 52 ans d'indépendance, c'est la première élection libre,
in
démocratique.
In 52 years of independence, it's the first democratic elections to take place.
C'est passé dans des conditions de transparence et de crédibilité reconnues par tous.
It took place in transparent conditions and on fair play and credibility known to all to the international community.
Et aujourd'hui, la République de Guinée a à sa tête un président démocratiquement élu.
And today, the Republic of Guinea is being headed by a president democratically elected.
Et la roue de l'histoire a repris à tourner dans le bon sens.
And the wheel of history has again entered into action.
La Guinée a repris, renoué ses relations avec la communauté internationale.
Guinea has restarted its cooperation, its relations with the international community.
Et s'engage dans une démarche positive pour le respect des accords passés avec cette communauté.
And commit itself to all of the accords that were signed between it and the international community.
Le Conseil national de transition est appelé à disparaître.
The transitional council will soon be given way.
Aussitôt que l'Assemblée nationale est installée.
As soon as the National Assembly is put in place.
Monsieur le Président,
Mr. President,
ma présence autour de cette table ronde est le signe évident
my presence here on this round table is evidence
de l'importance que les autorités de mon pays accordent aux droits humains.
It's evidence of the importance I give to human rights by the leaders of my country.
À leur portée universelle.
Yes, universal perspective.
À la lutte contre l'impunité pour les crimes les plus graves.
The fight against impunity for the most heinous crimes.
À la prévention de leur récurrence.
And the prevention of their recurrence.
À l'existence, à l'effectivité et à l'impartialité de la Cour pénale internationale.
The effectiveness and the impartiality of the international court.
Dont la Guinée est à partie.
To which Guinea is a member, is a full member.
En vertu de sa ratification du Statut de Rome.
In view of the ratification of the Statute of Rome.
Intervenu depuis juillet 2003.
Which took place in July 2003.
Mon pays s'est engagé résolument.
My country resolutely committed itself
dans un processus de franche coopération et de complémentarité avec la Cour pénale internationale.
In the process of cooperation and complementarity with the International Court.
Et c'est conscient de ce principe de complémentarité
it is in view of this principle of complementarity
que nous connaissons tous
that we all know
que la République de Guinée s'est engagée aux côtés de la communauté internationale
that Guinea committed itself to the side of the International Committee
pour mener les enquêtes indispensables en vue de faire toute la lumière
in order to carry out investigation, in order to make to shed light
sur les événements dramatiques du 28 septembre 2009 dont parlait la procureure adjointe de la CPI.
On dramatic events to which the Deputy Prosecutor alluded to in intervention.
À l'occasion desquelles des graves violations des droits de l'homme ont été perpétrées dans mon pays.
During this event, grave crimes were committed against humanity.
Pour ne citer que les plus récents.
Only to cite the most recent ones.
Se fondant sur les conclusions des rapports des différentes commissions d'enquête mises en place.
To take into account the recent accords put in place
par le secrétaire général des Nations Unies,
by the Secretary General of the United Nations,
par le gouvernement de mon pays,
by the government of my country,
et par différentes ONG,
and by different
NGOs. Mon pays a saisi la CPI et le bureau du procureur de la Cour pénale internationale.
All of these things, but what are you doing?
I talk to you not only as a politician but as a lawyer too. In your view, what are the steps needed to be taken by Liberia, given that Liberia already ratified this treaty, that will create a condition wherein we can be able to address through our legal system these kind of situations that will stop us from going to the RCC, and not only Liberia but other participating countries who are all signatory to the RCC? What do you think are the enabling environment, and what step are Liberia taking, and what step remain to be taken by Liberia? Thank you.
And you will tend to agree with me that this legislature, in collaboration with the President of the Republic of Liberia, have taken a lot of practical steps to ensure that the goods are delivered to our people. It was you and myself through the collaborative effort, it was through the collaborative effort of this legislature and the executive branch of government, we passed all of the supporting legislation that led us to the process of debt waiver. We recommitted ourselves through this legislature to all of the outstanding international obligations of Liberia. So to go into details, I know you just want to hear something from my mouth, and I know why you want to hear it.
The RCC work along with individual legislators or legislative bodies so as to disseminate information regarding the Rome Statute, because this is very important. You know, we need to create a collaborative working mechanism that will ensure that information about the Rome Statute is adequately disseminated in our respective member states. Thank you. On this note, we want to thank you so much for your participation in this forum. We now honorably ask our panelists to recess. Thank you. And we invite to the podium Dr. Bernadette Lahai of Sierra Leone and Mr. Boubacar.
To end up with a statement that encapsulates all the issues that have been discussed, the concerns and the hopes of PGA in the furtherance of our respective work in our respective parliaments. So to this end, colleague, members of parliament, it is my pleasure, having listened to all that you have said this morning, to read out a statement concerning what we as PGA members think of the ICC and our various work. I read, we, parliamentarians from Liberia, Mali, Côte d'Ivoire, Ghana, Guinea, and Sierra Leone, from countries that have all accepted the jurisdiction of the International Criminal Court. 1. Recognize the importance of the International Criminal Court as a means of preventing impunity for crimes of the most serious nature, genocide, crimes against humanity, and war crimes. Take note of the important principle of complementarity as included in the Rome Statute of the ICC, which gives precedence to national legal systems in the prosecution of such crimes, except where national authorities are unwilling or unable to investigate or prosecute crimes. Undertake, therefore, and as appropriate, to seek to put in place the necessary implementing legislation, including legislation on cooperation, to give effect to the Rome Statute of the International Criminal Court within our respective countries without undue delay. Agree to remain in contact with each other so that we can continue to share our respective and useful experiences, including any new steps or measures that we may take in this area. Note our interest in receiving any information that we may consider appropriate or useful in assisting us with progressing our respective implementing processes, and express our profound appreciation to the Legislature of Liberia and PGA for organizing this regional roundtable consultation on implementation on the Rome Statutes of the ICC, done in Monrovia this 9th day of February 2011. I now would like all members here to give a big applause for this statement as a sign of our acceptance of this statement. Honorable Senator Siakor, our host, to give the closing vote of thanks.
Who took up your time to come to this meeting, this regional roundtable. I think the first thing Q goes to the office in New York, to Peter, Stephanie, Michael, and others who chose Liberia as the venue for this very important discussion. And thank you for all the efforts you made to make it possible. And we'd like to thank our brothers and sisters from Sierra Leone for the long journey over road to come and be a part of this discussion. And we also like to thank our brothers from Ivory Coast. We know they are going through a very difficult time, and to have taken up the time to leave the country and come to Liberia, we think is a very good move. And we will encourage you to engage further with the PGA so that the PGA can maybe understand the situation in Ivory Coast better, so that it will play a role that will help the peace in Ivory Coast to be restored. So thank you for coming. And we thank also our friends from Guinea. I think this is the first time we've seen Guinea in this meeting. And our Francophone brother from Mali also. So we'd like to thank you for taking the time to come to this meeting. Even though I don't communicate well in French, I'm hoping I will have your email addresses, and once in a while we can communicate a little bit so that we keep the contact on some of these issues. And we also like to thank our colleagues from Ghana and our colleagues from, I think the person from Senegal still has not made it, and the parliamentarian from Ireland has already left. The deputy prosecutor for the court also we'd like to thank for taking that time